Good evening, ladies and gentlemen. I'm going to put this out there as a food for thought. A lot of you guys are struggling in areas. You're searching for some answers. You're asking people for things. And I'd like to propose a number of questions for you all tonight to help you in your research. So a proof of claim, if you will. And if you want to write these down as I go through them and look them up, I'm going to provide you the information, and it's up to you to go look at it. Maybe this will help you have a higher understanding of what it's all about. It doesn't have to do with right and wrong. It doesn't have to do with morality. It's quite the polar opposite. It's about deception and the fraud that we've all been immersed in. So the legal status of these non-constitutional legislative entities operating, functioning as source of authority for these so-called revised codes and statutes, and specifically the United States Code and or specifically the Act of March 9th, 1933, Proclamation 2038, 2039, 2040, and Title 4, 7, 11, 12, 15, 16, 18, 28, 31, 42, USC, okay? CFR, the Federal Registry thereof, is not that of a corporation, quasi-corporation, which is also created by statute, see 73, Corpus Juris Secundum, Public Administrative Law and Procedures, subsection 10, page 372, citing Parker versus Unemployment Compensation Commission. 214, S is in Sam, W is in Word, 2D, 529, 358, MO, 365, which states, the powers granted to an administrative body may be such as to establish it as a legal entity, and although not expressly declared to be a corporation, it may be considered a public quasi-corporation. Texas and Pacific Railway versus Interstate Commerce Commission, 162, U.S. 197, 1895, which states, the Interstate Commerce Commission is a body corporate with legal capacity to be a party plaintiff or defendant in the federal courts. 2. Amjuris edition 2D. Administrative Law, subsection 32, public, page 56, which states, some administrative agencies are corporate bodies with legal capacity to sue and be sued. Okay? Proof of claim number 2. That the Legislative Reference Bureau, created by Act of April 27, 1909, Public Law 208, and recognized by Act of May 7, 1923, Public Law 158, as a legislative agency with the primary function to draft and pass upon legislative bills and resolutions for introduction in the General Assembly, and to prepare for adoption by the General Assembly codes by topics and or the existing general statutes for which it was handed over statutory authority in 1974 to publish an official publication of the United States Code, is not operating, functioning as a non-constitutional legislative entity, and is not operating or functioning as a foreign corporate entity representing the source of authority for the existence of statutes, laws known as the United States Code in the capacity of an administrative law agency, administering the corporate affairs and public of that which created it by statute. Okay? These are proof of claims, ladies and gentlemen. And you use these to challenge these people. Because if they cannot answer this, they cannot rebut it. What happens, ladies and gentlemen, in contract law? What happens in equity when you ask some questions and people have a duty to inform you and they fail to, or they can't rebut or rebuke these statements, these facts, these questions? What happens? Number 3, these alleged statutes, laws of this non-constitutional legislative entity, the Legislative Reference Bureau, operating, functioning as a foreign corporate administrative law agency, are not by nature akin private bylaws of a corporation for the administration of its internal government and public, and are binding and of force or effect over and upon the private, non-enfranchised, and non-assumpsate thereto, and therewith living, breathing flesh and blood man, i.e. a natural person man, and as such are not ultimately governed by, through, and within the realm of commercial law, as adopted and codified within the United States Code thereby, and therein representing commercial law for operating functions in commerce. Okay? Number 4, where the Constitution for the United States of America at Article 1, Section 8 and 10 clearly prohibits the Congress from printing and issuing Federal Reserve notes as it is a constitutional entity, or purportedly so, and its actions are limited thereby, and therein a corporation or trust is not. Ergo, the Federal Reserve System created by Congressional Act in 1913 and as a non-constitutional congressional entity without the Constitution, and therefore not bound nor encumbered by said documents, instruments, may proceed to print and issue money, currency, because it's not money. That's one of the things I don't like in this. When they state money, money is gold and silver, folks. Currency can be a number of things. It can be wampum. It can be pelts. It could be a number of things, which would be an unconstitutional form of money for Congress, restrained as it is by the instrument document of its creation. These non-constitutional legislative entities, ergo, the Legislative Reference Bureau, and the alleged statutes, laws they generate, is not a non-constitutional issue having no nexus with the Constitution. And the binding force or effect of said statutes, laws, is not established, created solely from or by contract between the parties, which once silent judicial notice of said contract is taken by the holder in due course, any affidavit in support thereof, and specifically within the above referenced alleged loan, debt, security instrument, unless said presumption of a contract is rebutted. Please take note. Please note that although it is the United States Treasury Department who prints the so-called Federal Reserve note, these notes have no value and are not backed by anything. Federal Reserve notes are not redeemable and receive no backing by anything. This has been the case since 1933. The notes have no value for themselves. And what he's articulating here, ladies and gentlemen, I've showed you multiple times. Bear with me just a second, and I will show it to you again.
Player evaluations coming up for the new season. It's an exciting afternoon. There's barbecuing and games for the kids, music. Be nice if you could come up.
This is a silver certificate. It is a receipt, redeemable for one of these. A nice piece of silver. Metal intrinsic value. It's had value for tens of thousands of years and will continue to have value for tens of thousands of years. The FRN note is backed by nothing. This is a receipt for one of these. And this receipt comes with a series of numbers to help identify this receipt being in circulation for this particular piece here. They could only print as many of these as they had of these, period. There was no interest, there was no inflation, because if you didn't have it, you couldn't print it. And that's where you balance the poverty, the middle class, the alleged first class. That's how you balance. You bring balance back to a system, is by creating a form of money which God made perfect for us, that is limited in supply, that keeps an equal value and balance throughout an economic system. And that's what this is. Man cannot create this. And because man cannot create this, there's only as much as there is, or as much as has been found. So even when there's an economic boom, the fact of the matter is, there would still have to be more of this pulled out of the ground to have any monetary fluctuation as far as the difference in value, which would be minuscule and slow and at a pace that everybody would be able to enjoy. With the fake monetary system they have, they can literally bankrupt every last one of you tomorrow with a flick of a button, and it's gone, poof. And for those of you think that I may be off my rocker, let's review 1929, because everybody's so quick to forget about the past and the real history of this nation. Okay? The bankers intentionally caused the economic crash that was known as the Dirty 30s. 1929. They intentionally caused that. Okay? We'll go on. The above reference quote is taken from the official website of the United States Financial Excerpt, the United States Department of the Treasury, whose job it is to print the money to be utilized by the public. And note how they say that since the government declared bankruptcy in 1933, their notes have had no value. Why? Because they're not backed by something of physical solid asset with intrinsic value. They're not backed by anything. It says it in the Bible. Gold and silver is good, and interest shall not be had. Interest is a bad thing, ladies and gentlemen. The world is abundant and plentiful and has been designed that way for us all. You could fit the entire populace of the world in the state of Alaska, and people would still have enough room not to hear their neighbors sneeze in the middle of the night with the windows open. Okay? The Federal Reserve issues bookkeeping entry credit. There is no constitutional amendment permitting the Federal Reserve and or the Treasury to create worthless items and declare them to be currency. The Constitution has held that the monies created by Congress must have a value, and this is not a market value, but a national currency value. Federal Reserve bookkeeping entry credit is not regulated by Congress, making this process by the Federal Reserve, the issuance of bookkeeping entry credit, unconstitutional. That is, unless and until you can provide facts and conclusions of law and not opinion to the contrary, okay? And it lists a Treasury website, Governor Resource Center, facts, currency page, legal tender, .aspx. Proof of claim that the original lender did not lend bookkeeping entry credit in the form of a loan and failed to provide such notification and clear, unambiguous, conspicuous language, terminology that any reasonable man or woman would virtual information concerning said debt and all of the matrix involved in making the loan That's Desh Bank versus Peabody, 866 New York, or NYS 2D 91 2008. Equifirst, when making the loan, violated Regulation Z of the Federal Truth in Lending Act 15 USC subsection 1601 and the Fair Debt Collection Practice Act 15 USC subsection 1692. And something I find very intriguing about the Fair Debt Collection Practice Act is the very first word in that act is fair. And what is fair? It's equity, ladies and gentlemen. That's equity. And equity is a very, very powerful jurisdiction to be in if you know how to bring it forward and you know how to stand in it. Okay, because equity sees that what should be done shall be done. There's no gray, muddy water area that allows these attorneys to do things in that nature. Equity is very, very clear. It's black and it's white. It's either right or it's wrong. There is no in between. Proof of claim that the banking holiday proclaimed by President Roosevelt under Proclamation 2039 prohibiting any banking during the course of such emergency to include but not limited to deposits, credits, receipts, withdrawals within and between banking institutions has been suspended, declared over, abolished, and repealed. Okay? Again, we're looking for them to answer this. They can't. They can't because it's factual and we're going to show it later. Proof of claim that the government loan represented by this account is not backed by the full faith and credit of the United States government because under, I believe it's USC 31, all debts are the obligation of the United States and have been so since, I believe it's 1913. If not 1913, absolutely positive by 1933 with House Joint Resolution 192, okay? There had to be a remedy for the blatant theft of your great-grandparents' wealth. And because of that, House Joint Resolution was created. There for a short period of time, believe it or not, the American people, because of the situation that had unfolded, actually did have access to things and with their mere signature would leave the lot with what they needed for their farm, for whatever. And then they slowly bled that off, like all good government programs. They give you the good stuff right at first, and then they just start cranking it up because they use everything they're doing to essentially dig deeper into your pocket. And let's compare it to like cell phones. Back in the day, data used to be free. As soon as everybody started using data, as soon as everybody needed their fix of data so they could do what we're doing now, all of a sudden, well, it's just $5 a month for your data. Now it's about $95 a month for your data. You see, we give you something, just enough to lure you in. We let you use it for a while so it becomes convenient, which later becomes a commodity or an asset. And then we drive up and drum up the prices. We justify raising your taxes because now you guys need this. Now that you've experienced it, you need it. There's a want for it. There's a demand. And that's what we call business. That's what we call commerce. Okay. That the banking holiday proclaimed by President okay, I read that one. That the government loan represented by this account is not backed by the full faith and credit of the United States government. That the government loan represented by this account is not secured by mortgage insurance. Okay, that's another important thing. When you guys miss a home loan, a car loan payment, these alleged loans, they're insured. And the second you miss that payment, it is paid off by the insurance company. So who do you owe if they don't still hold that promissory note? If they don't hold the original promissory note, they are not the holder in due course, ladies and gentlemen. Now, here's how they're getting you guys. They're getting you to sign private security agreements with them. When you're signing that promissory note, you're also signing a number of other documents. You're not reading them. You're not paying attention to what they're doing. They're latching on to your equity, your sign of nature, your money that you're creating, essentially as a private banker, even though you don't have that status. You're not a private banker. They're the private side of banking. But what they're doing is they're utilizing your sign of nature to generate new currency. And so what they do is they actually access your credit. They take your credit, they take it from one account and they stick it into another account, and they make it appear as though they lent you something. But in all actuality, they stole your credit, they gifted it to themselves without telling you, they reissue it to you under the guise that it's a loan, and then they have you sign some documentations, some security agreements that binds up your credit, your promissory note, to ensure that you now have to pay them, and they use your property as collateral to ensure that you're going to pay them. They're getting paid, could be 6-7 times what the actual alleged loan is, with fractional reserve banking and all of these things, and the money's on account, the credit's on account. What these people are doing, ladies and gentlemen, is just absolutely bewildering. I can't believe I've gotten as far as I've gotten in studying this. And most people will never understand this, guys. So share this video. I'm not done yet. I've got like 42 of these questions and these statements of facts that just cannot be beaten. You ask any of your attorney friends to review this video and beat these proofs of claim. It cannot be done. Ladies and gentlemen, it cannot be done. That the government loan represented by this account is not secured by mortgage insurance, and that the holder in due course is the beneficiary of that mortgage insurance. That the mortgage insurance is in place should the borrower default. Now, if the borrower, and again, it's a play on words, because really you're the creditor. You're not the borrower. You're the creditor. But the way that the bank is doing these sleight of hands, using these instruments, they get a mortgage insurance. And so as I explained to you earlier, they're getting paid before they foreclose on you. They're getting paid from the insurance. The note's been paid once by the insurance. And I guarantee you, it doesn't happen every time. They're getting a little slicker about this. But most of the time, your promissory note is sold. They're not even the holder in due course anymore. I was just in a court where the judge allowed the ministerial administrator who works for the Bar Association, and when you look at Black's Law Dictionary, judge is banker and banker is judge. So this isn't too far-fetched here, ladies and gentlemen. I'm just taking a stab at this. She said that the uncertified copies of the promissory note would suffice as evidence as far as she was concerned. And when the man was asking for the original note, the banker said, well, I believe, and keep in mind, he was a vice president, CEO banker, okay? He said, I believe the original note is in the vault. Well, I believe and I know are two different things. And if you're going to have me wrapped up in court and try and steal things from fellow Americans around me, I don't want to know what you believe. I don't want to know what you think. I don't give a flying bat turd what you might have known or might have been. I don't care about any of that. Show me that you physically still have the promissory note, and that by all rights you are the holder in due course, that you have not sold that instrument. And if you're the owner of the instrument, how did you become the owner of the instrument? Did you find that instrument and I have an equitable interest in that instrument because it correlates and was created and generated by me? Or did you buy it from me and you can provide a full accounting and the best evidence ever, a receipt for that promissory note? Where is it? If you own it, I need to see those forms of evidence, and not certified copies, and not just words spewed from a man who thinks. Show me the money. Have a Jerry Maguire moment in that courtroom. Show me the money. Show me where it's at, baby. That's how that guy paid in coffee beans. They can't show anybody no money. It don't exist. I had a judge, and I can testify to this with firsthand knowledge. I had a ministerial administrator, the unflappable. I've got a lot of respect for this guy. He's very cool. He was teaching me things. I asked him one time, I said, let's just stop with all the shenanigans. You say I owe a debt? Just tell me how to pay. Just tell me how you want me to pay. Clasped his hands, big old grin on his face. He liked it. I could tell. It's just bravado, you know. Here's a young man standing up going, all right, let's do this. And he leans forward and says, Benjamins. I'm looking around the courtroom. What the hell do you mean by Benjamins? Objection, point of clarification. I need to know what you mean by Benjamin, what a Benjamin is, where I might find some Benjamins. I mean, how many of these Benjamins do you want? He says, I'm not going to answer that. And I said, well, objection, point of clarification. How am I supposed to give you a Benjamin if I don't know what it is? What do you want for payment? And he leans forward again and says, Benjamins. Bailiff, get him out of here. Okay? That's the slick willy crap that they do. How hard would it have been to say FRN, Federal Reserve Note, for that man? I mean, if that's truly what you're after. But see, with a gentleman like me, he finds himself in a lot of trouble if he says FRN, Federal Reserve Note. Because you see, I understand what an FRN note is. It's a promissory note to pay in the future, but worse off than that. Worse off than that. Okay, it's an IOU, but it's not even my IOU, ladies and gentlemen. It's the IOU of a private entity. Okay? Now this is where it gets good. Because if he'd have said Federal Reserve Note, can any man force me to do business with a private corporation or a private man or a private firm of any kind? The answer is no. And what is your proprietary interest in me using said private intellectual property of another corporation? You see, here comes the anti-bribery statement. Here comes the 1099-Rs. Here comes the questions about who do you really serve? You know, when they start telling you Federal Reserve notes and you start asking hard-hitting questions about what proprietary gain do they get from forcing you to use a private entity to pay scrupulous amounts of paper? And better yet, how do I acquire that FRN note? And where do I get it? Because remember, he who provides an ends provides the means. If I tell you you need to go get something and you ask me where it is, but I can't tell you where it is, do I really have an expectation for you to go bring it to me? No, absolutely not. Absolutely not. So he who provides an ends provides the means. If I'm asking you to go get a round square, I better be able to tell you where you can find a round square. And that's an old greenhorn joke for you construction guys out there. So, okay, proof of claim that the property securing the loan and unsecured loan has been fully paid as a result of the Treasury program and or other government programs respecting or associated with such loans, programs like the Single Family Home Loan Guarantee Program, etc. Again, these are insurance programs, people. And these notes are being bought and sold. Think about this. A mortgage, a promissory note is issued. Think about how many times people have issued a promissory note at a bank for the home that you are currently in tonight. Think about that. When do those promissory notes ever expire? How about the ones that are foreclosed on? Are they still floating around out there? Who has those promissory notes? Are they still being traded on the IMF stock exchange? And how many times has your home been paid for over and over and over and over again with a promissory note? Just food for thought. Where are those instruments? Because you're not getting them back. You go to McDonald's, you order a cheeseburger, you get the cheeseburger and a receipt. Okay? Think about your promissory note. Where's your receipt for that credit that you've created, that energy that you've created? Proof of claim that issuing the loan in the form of bookkeeping entry credit was deceptive, intentional, and deliberate attempt to conceal pertinent information regarding the origination of the loan and the matrix associated thereto. Proof of claim number 12, that tax credits and or charge off whereby the government has issued credits respecting the associated loan debt has not been applied to the borrower's side of the ledger, indicating the adjustment in balance. Proof of claim number 13, that the Uniform Non-Judicial Foreclosure Act, the Uniform Home Foreclosure Procedure Act, the Administrative Procedures Act do not recognize arbitration as an alternative dispute resolution remedy. That's what this is. This is an arbitration, ladies and gentlemen. This was a first notice in a private administrative process, okay? So this is how it started out. You have to cultivate a notary in order to do these things, ladies and gentlemen. This is absolutely how it works. Account and the same deadline for furnishing a response to this presentment is the exact same deadline for furnishing the accounting as is demanded. Proof of claim number 16, that your organization nor the original lender ever intended on limiting lawful money as required in law, okay? Regulated by Congress and prescribed by the Constitution of the United States of America. Proof of claim number 17, that there is no lawful statute under the Constitution delegation of authorities authorizing your institution in creating bookkeeping entry credits as a form of acceptable currency within the United States. Ladies and gentlemen, that's so powerful. Less than 1/8 of the alleged trillions of dollars that are out there actually exist in a physical, tangible form. Ladies and gentlemen, the loan is ones and zeros on a computer screen. It's not even on paper anymore. It's not printed on paper until they want to fleece you in a court and try and act as though they've lent you something and you have an obligation and a duty to perform and lend you anything. What they did was conning you into signing a security agreement that bound you to them and pledged your property as collateral and made you the debtor for an alleged loan that they never lent you. And then they guise it as a mortgage, ladies and gentlemen. All right. That there is no lawful statute and or constitution delegation of authority authorizing the institution in creating bookkeeping entry credits as a form of acceptable currency within the United States. Number 18, that all property in the United States is owned by the state by virtue of government. That is so important. How can the government own anything if they're $22 trillion in debt? Holy shit. It's a George Carlin question, right? It's one of those stupid oxymorons almost. How can you own anything if you're insolvent? And furthermore, how can you tell me I owe anything if you're insolvent? You know? And if nobody's solvent in here, how are we supposed to pay anything, right? Right. How are we lending all these funds to other countries and supplying people with arms and all this other stuff if we're 22 trillion in the hole? Come on. You don't get out of debt as a businessman. I'm here to tell you right now, you don't start a business in debt. You don't operate in debt. It doesn't work that way. But again, I say that, and it's almost an oxymoron because an FRN note is just that. It's an IOU, a promissory note of pay, not backed by any physical metal or anything of intrinsic value. And so again, you know, think about these things. This right here will help you if you follow it. That all property is vested in the United States by virtue of government, that the following statement and or record of Congress remains extant. Mr. Speaker, we are here now in Chapter 11. Members of Congress are officials, trustees, presiding over the greatest reorganization of any bankrupt entity in the history of the world. In world history, the U.S. government, we are setting forth, hopefully, a blueprint for our future. There are some who say it is a coroner's report that will lead to our demise. Representative James Trafkent Jr., Ohio, addressing the House Congressional Records March 17th, 1993, which would have been when Bill Clinton was in office, volume 33, page H1303. Proof of claim that as the banking institution, the borrower may utilize bookkeeping entry credits as a form of acceptable currency as it was the initiating currency of issuance. Now, therefore, I, Franklin D. Roosevelt, President of the United States of America, in view of such national emergency and by virtue of the authority vested in me by said act, do hereby proclaim order, direct, and declare that there shall be maintained and observed by all banking institutions and all branches thereof located in the United States of America, including the territories and insular possessions, a bank holiday, and that during said period all banking transactions shall be suspended. During such holiday, no such banking institution or branch shall permit the withdrawal or transfer in any manner of or by device whatsoever of any currency, nor shall any such banking institution or branch pay out deposits, make loans or discounts, transfer credits, or transact any other banking business whatsoever. During such holiday, the Secretary of the Treasury, with the approval of the President under such regulations as he may prescribe, is authorized and empowered, A, to permit any or all of such banking institutions to perform any or all of the usual banking functions. B, to direct, require, or permit the issuance of clearinghouse certificates or other evidence of claims against assets of banking institutions. And C, to authorize the creation in such banking institutions of special trust accounts for the receipt of new deposits, which shall be subject to withdrawal on demand without any restrictions or limitations, and shall be kept separately in cash or on deposit in the Federal Reserve banks or invested in obligations of the United States. As used in this order, the term banking institution shall include all Federal Reserve banks, national banking associations, banks, trust companies, savings banks, building and loan associations, credit unions, or other corporations, partnerships, associations, or persons engaged in the business of receiving deposits, making loans, discounting business papers, or transacting any other form of banking business. Proclamation 2039 declaring banking holiday March 9th, 1933, public papers and address of Franklin D. Roosevelt, declared law by the General Assembly, U.S. Congress, March 9th, 1933, and the act associated by the same name. Proof of claim 21. That the loan and the associated debt is an obligation of the United States as defined in statute. September 14th, 1976, the Senate Special Committee had found that President Roosevelt's 1933 proclamation of the national emergency was still extant. See Senate Special Committee on National Emergencies and Delegated Emergencies Powers. Final report, National Emergencies and Delegated Emergencies Powers, report number 94922, 94th Congress, 2D, Session 1976, PL, Public Law, I believe, 94412, September 14th, 1976, 90 Stat 125550, USC 1601 ET Sec. Proof of claim number 22, that the ownership of all property is not in the state and that individual so-called ownership is only by virtue of government, i.e. law amounting to mere user, and that use must be in accordance with law and subordinate to the necessities of the state. Senate document number 43, 73rd Congress, first session. Proof of claim that under the new law, the money is issued to the banks in return for government obligations. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. That it represents a mortgage on all the homes and all the people of the nation. Congressional Record, March 9th, 1933, on House Resolution 1491, page 83. Proof of claim number 24. That it has been resolved by the Senate and the House of Representatives of the United States of America and Congress assembled that a Every provision contained in or made with respect to any obligation which purports to give the obligee the right to require payment in gold or a particular kind of coin or currency or in an amount in money of the United States measured thereby is declared to be against public policy. What's public policy and what's law, ladies and gentlemen? Research it. And no such provision shall be contained in or made with respect to an obligation there hereafter incurred. Every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any such coin or currency, which at the time of payment is legal tender for public or private debts. The Gold Abrogation Act of June 5th, 1933. If you do not understand what I just read to you there, please go look this stuff up. Get a dictionary out and understand the language and the terminology and the context for what they're using. That since March 9th, 1933, the United States has been in a state of declared national emergency. These proclamations give force to 470 provisions of the federal law. These hundreds of statutes delegate to the president extraordinary powers exercised by Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together confer enough authority to rule this country without reference to normal constitutional process. Senate Report 93-549, July 24th, 1973, that the following is the current understanding. Mr. McFadden, the first section of the bill, as I grasped it, is particularly the war powers that were given back in 1917. I would like to ask, hold on a second. I would like to ask the chairman of the committee if this is a plan to change the holding of the security back of the Federal Reserve notes to the Treasury of the United States rather than the Federal Reserve agent, Mr. Stiggles. This provision is for the insurance of the Federal Reserve Bank notes and not for the Federal Reserve notes. And the security back of it is the obligation notes. Obligation notes, drafts, bills of exchange, bank acceptances outlined in the section to which the gentleman has referred. McFadden. Then the new circulation is to be Federal Reserve Bank notes and not Federal Reserve notes? Is that true? Stiggle. Insofar as the provisions of this section are concerned, yes. Mr. Brighton. From my observation of the bill as it was read to the House, it would appear that the amount of banknotes that might be issued by the Federal Reserve System is not limited. That will depend entirely upon the amount of collateral that is presented from time to time from exchange from banknotes. Is that not correct? McFadden. Yes, I think that is correct. The congressional record during the debate over the Emergency Banking Act of 1933. Number 27, proof of claim. That the amendment of subsection 5B provided that the act can only be invoked during the time of war. The elimination of the exclusion made clear that any and all emergency powers that might have previously been available pursuant to a national emergency declared under subsection 5B, Congress did not formally terminate the one declared by President Roosevelt, apparently believing that only the president could do so. And so 50 U.S.C. APP 5B, 12 U.S.C. 95A, in amending TWEA, Congress did provide for the continuation of the emergency and of any economic sanctions that were the result of the presidential declaration of the national emergency that were in effect on July 1st, 1977, subject to automatic termination unless they were renewed annually. This provision allowed the constitution of the national bankruptcy, the continuation of the national bankruptcy and the national banking holiday, as well as the sanctions on regimes like Cuba, North Korea, China, and North Vietnam, to continue without the president having to declare a new national emergency under the IEEPA, see 50 U.S.C. APP 5 note. 28, proof of claim. That as first adopted in 1976, the National Emergencies Act excluded from its purview Section 5B of a Trading with the Enemy Act, as noted above, the law under which President Roosevelt issued a declaration of national emergency with respect to the national bankruptcy was never canceled. With the Cold War section under that act had also been used by the executive branch as a legal bias for imposing economic sanctions on the communist nation of North Korea, Cuba, China, and North Vietnam, and the National Emergencies Acts had been terminated. There would have been no other legal bias for continuing the sanctions against those countries except to enact a set of new specific laws Congress chose not to consider. As a consequence, the State Department asked that Section 5B be excluded from National Emergencies Act until other legislation providing a bias for the continuation of economic sanctions against those countries could be enacted. Is this not the case? Proof of claim number 29, that whenever in the judgment of the Secretary of the Treasury, such action is necessary to protect the currency system of the United States, the Secretary of the Treasury, in his discretion, mind you, may regulate any or all individuals. Whoever shall not comply with the provisions of this act shall be fined not more than 10,000, or if a natural person may, in addition to such fine, may be imposed for a year, not exceeding 10 years. Stat 48, Section 1, Title 1, subsection in March 9th, 1933, that it is under discretion and the direct supervision of the United States Treasury that the banking institution are utilizing bookkeeping entry credits. And because the law defines a banking institution as one who engages in the business of banking, i.e. banking business, during the current national banking emergency defined in law as bankruptcy, such bookkeeping entry credit utilization is construed as currency of the United States and may be utilized for the payment and or repayment of a loan instituted and or issued in the same species. Is this not so? Goes on, CAVEAT, C-A-V-E-A-T. Please understand that while the undersigned wants, wishes, and desires to resolve this matter as promptly as possible, the undersigned can only do so upon respondents' official responses to the conditional acceptance for value and counteroffer claim for proof of claim by respondents, providing the undersigned with the requested and necessary proof of claim raised herein above. Please consider this account in formal dispute and protected under, without limitations, 5 U.S.C. subsection 571 and 584 through 584, U.S.C. 15 subsection 1692 through 1692, page 12, CFR 226.13 D12, account in formal dispute are as follows, and it goes on for the accounts. Therefore, as the undersigned is not a signatory nor a party to your social compact contract known as the Constitution, Charter of the United States, nor noticed nor cognizant of any agreement, contract between the United States and the undersigned, and specifically any obtained through full disclosure and containing undersigned and specifically any obtained through full disclosure and containing any fair valuable consideration therein, which would act operate to create, excuse me, got interrupted there. Okay, and containing any fair valuable consideration therein, which would act operate to create and establish a relationship, nexus thereby and therein, binding the undersigned to the specific source of authority for the creation and existence of the alleged specific source of authority for the creation of the existence of the alleged statutes, laws as contained and allegedly promulgated within the code known as the United States Code, which with the privity of contract or contract itself would thereby and therein create and establish legal force and or effect of said statutes, laws over and upon the undersigned, and would also act, operate to subject the undersigned to the statutory jurisdiction of the United States, its laws, venue, jurisdictions, and the like of its commercial courts, administrative tribunals, units, and thereby and therein bind the undersigned to said courts, administrative tribunals, units, decisions, orders, judgments, and the like, and specifically as within the above referenced alleged commercial civil cause, and which would act, operate to establish and confer upon said court, administrative tribunal, unit, the necessary requirement essential of subject matter jurisdiction, without which it is powerless to move in any action other than to dismiss. The undersigned once more respectfully requests the respondents provide said necessary proof of claim. When we're asking for the necessary proof of claim, we're talking about necessity. That's equity, right? We're back into equity. It's necessary for these guys to bring forth the original documents, to bring a full accounting. I want to see where those funds came from, when they were transferred from one account to another, who owned the one account they were created in, how did they end up in the other account, where's the receipt for the promissory note, when did you buy it, when did you ascertain it, when did it become yours? You know, these are the necessary things that they must have to move forward with their claim. You can never let these people move forward with presumptions and assumptions, ladies and gentlemen. You will lose every time. So, proof of claim. So as to resolve the undersigned's confusion and concerns within these matters, otherwise the undersigned must ask, what is the undersigned's remedy? Okay, how do we pay? If there is such a debt and you can't prove it, where is the debt? First of all, if you can't prove it, I don't care what you signed. If you don't have the original instruments, you're not the holder in due course, then I owe you nothing. And if I owed you something, then show me when I was paid or when you yourself lent me anything. You know, the bank doesn't lend you anything. According to some of these documents that I've been reading through of people's banking information, they often say that it was the CEO that did the lending. Well, we start to evaluate the CEO's entries in his own accounts. Let's see how he would have had the capacity to be able to lend that. One of the things the banker said in court the other day that I just thought was just hilarious. We lend depositors deposits. Really? You lend deposits. And he didn't say it in that fashion. He said, we lend deposits. And I'm thinking to myself, well, whose deposits? And how does the depositor get their deposits if you've lent them out? Food for thought, right? But never mind that, because less than 1/8 of this crap is actually printed. It's all ones and zeros on a computer. Ladies and gentlemen, it's double bookkeeping entry. It's the same thing that Bernie Madoff guy went to prison for not too long ago. Ponzi scheme, allegedly. Double bookkeeping entry, taking funds from here, hiding them over there, spending them over here. Only the government and the Federal Reserve do it at a phenomenal rate with zero oversight, zero, and have the American people convinced that somehow you owe a debt. I don't know how you owe a debt and where the beneficial interest is in you participating in the thing they call a society of debtors, when the Bible is very clear that you're not supposed to be a debtor. Jesus died for all your debts, both commercial and your sins. I mean, look at it however you want. Just trying to point out the obvious. With that said, the rest of this just goes into a diatribe of rhetorical things. Notice of common law arbitration. All right, we'll get into some of this. We'll get into some of it for you guys because there is some good stuff in here. All right, there we go. Notice of common law arbitration. Please be advised that inasmuch as the undersigned has secured the interest in the name of all capital letters named defendant as employed, used upon the face and within all documents, instruments, records within the above referenced alleged commercial civil cause, to include any and all derivatives and variations in the spelling of said name except the true name of the undersigned as appearing within the undersigned signature block herein below, through a common law copyright filed for record within the office of the Secretary of State of the State of Nebraska, and having perfected said interest in name, in same through incorporation within a financing and all amendments and transcending filing thereto. By reference therein, the undersigned thereby and herein waives the undersigned's rights as set, established, and the like therein, and as perfected within the financing statement acting operating to register said copyright to allow for the respondent to enter the record of the alleged court of record within the above referenced alleged commercial civil cause for the sole purpose to correct said record and comply with the respondent's agreed upon duty obligation to write the order and cause same to the transmitted to restore and release the undersigned's corpus and all property currently under a storage contract and under the undersigned's common law copyrighted trade named, i.e., the all capital lettered name defendant within the above referenced alleged commercial civil cause within the alleged commercially bonded warehousing agency, DBA, Federal Bureau of Prisons for the Commercial Corporate Government, Judicial Construct, DBA, the United States. Please take special note. The copyright is with reference to the name and its direct association and or correlation to the presenter. 41. Notice, the arbitration must not necessarily judge according to the strict law, but as a general rule ought chiefly to consider the principles of particular business. Norseke Atlas Insurance Co. versus London General Insurance Co. 1927, 28 Lloyd's List Report 104. Internationally accepted principles of law governing contractual relationships. Duchess, I'm going to slaughter this. Shachaba versus RA's National Oil Co. 1990. 1 AC 295. If the contract, valid or otherwise, contains an arbitration clause, then the proper forum to determine whether the contract is void or not is the arbitration tribunal. For example, see Heyman versus Darwin's Ltd. 1942 AC 356. 42. As the undersigned has no desire nor the wish to tie the hands of the respondent in performing respondent's agreed upon duty obligation as said, established, and agreed to the claim thereby created, cause a breach of said contractually binding agreement on the part of the respondents. Respondents is hereby and herein noticed that if a waiver of said copyright is not liable nor extensive enough to allow for the respondents to specifically perform all duties, obligations as set, established, and agreed, respondents to the specifically perform all duties, obligations as set, established, and agreed upon within the conditional acceptance for value and counteroffer claim for proof of claim. And again, this was not constructed by me, ladies and gentlemen. This was a former lawyer who wrote this up, and he was damn good at what he did. And obviously, I'm not at liberty to release this. I'm just reading it. A lot of it is circular in nature. The further I get into pages, you start to see the lawyer come out in this gentleman, and it just gets rhetorical. Those facts that I read to you at the very beginning, the facts, the proofs of claim in the very beginning of this video are so pertinent, and it's not even funny. I mean, he goes into explaining the importance of a notary. Here's another beautiful piece right here. Congress declares Bible the Word of God. Public Law 97-280, October 4th, 1982. Public Law 97-280, 97th Congress. Joint Resolution 96 Stat 1211. Authorizing and requesting the President to proclaim 1983 as the Year of the Bible. Whereas the Bible, the Word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation and people, whereas deeply held religious convictions spring from the Holy Scripture led to the early settlement of our nation, whereas biblical teachings inspired concepts of civil government that are contained in our Declaration of Independence and the Constitution of the United States. Whereas many of our great nation leaders, among the President Washington, Jackson, Lincoln, Wilson, paid tribute to the surpassing influence of the Bible in our country's development. As in the words of President Jackson, the Bible is the rock on which our republic rests. Republic, not a democracy. Stop listening to the propaganda that's on your news media every day about being a democracy. It's disgusting. If we're truly in a democracy, ladies and gentlemen, and there's 350 million Americans, and of those 350 million Americans, less than 49% of them vote, you don't have a damn democracy. Stop thinking that way. And I can assure you, there aren't enough slaves to equal 51% of the populace voting. I promise you that. 51% of the populace is not voting. They're not voting, people. It's a sham, it's a scam, it's a lie. So if you really think you're in a democracy, I got news for you. There are not 350 million deadheads out there following along with the government and voting. I can tell you that right now. In fact, there's a lot of dead people that are voting. A lot of people, what was it, Acorn or whatever it was, registering dead people that had literally been decomposing in the ground for 50 years were voting. You don't have 51% of the populace, and because you don't have 51% of the populace, you don't have a damn democracy, all right? You just don't have it. It's a republic. Rest, whereas the history of our nation clearly illustrates the value of the voluntary applying the teaching of the Scripture in the lives of the individual, families, and societies. Societies, not just a society, societies. Why? Because my idea of a society and your idea of a society are two different things, ladies and gentlemen. And just because you have a philosophy in a society that you wish to see develop doesn't mean that you're wrong, and it doesn't make my society any better than yours, okay? My society, do no harm to others, and mind your own damn business. Simple. Mind your own business and do no harm to others. It's that simple. And if you cause an incident or an accident by arrogance or ignorance, make it right. Do your best to make it right. Whereas the history of the nation is clearly illustrates the value of the individuals, families, and societies, whereas this nation now faces great challenges that will test this nation as it has never been tested before, and whereas that renewing our knowledge of and faith in God through Holy Scripture can strengthen us as a nation and a people. Now therefore be it. Resolved by the Senate and the House of Representatives of the United States of America in Congress assembled, that the President is authorized and requested to designate 1938 as a National Year of the Bible in recognition of both the formative influence the Bible has had been for our nation and our national need to study and apply the teachings of the Holy Scripture. Why is the Holy Scripture so important? Ladies and gentlemen, it is the original book of trust. Learn how to read it. There's a reason that 7,000 members leave the churches every year. They're starting to figure out that the 501c3 means they're receiving benefits from the alleged government. The alleged government is giving them the structure for which they are going to teach you the Bible. And if you take Bible and you dissect it and pick verses from here, there, and the other, I can make the Bible say 1,000 different things. I can bring forth 1,000 different messages by reading the Bible in that manner, by picking parts and chapters and sections of the Bible. I can make it say anything. Read it page for page, ladies and gentlemen. Genesis is not that big. Go through Matthew, go through David, go through it. It's not that dang big. Take it by chapter and read it. Don't hop, skip, and jump verses. Just read it. Ask your preacher sometime why he's hopping and skipping around the good book. That book is not designed to be hopped and skipped around. You're supposed to read it. In the beginning, the earth was without form, and space was void, right? Void of space. Read it. Read it. So with that said, I'm going to let you guys go this evening. Just wanted to point out some things to you. A receipt for actual money, something of intrinsic value. And go back and share this video with your friends, your family. Get them exposed to the truth. Ask your lawyer friends these questions that I just read to you. The proof of claims. Share it with them. See if they can answer any of this stuff. Don't let them blow smoke up your ass. Make them produce the proof. Show you the physical evidence. I just read it off of Congress and everything. You can find all the stuff that I just read. You can find it all. Now you have facts in your hand. Take it into the court and ask them, hey, you want me to pay? According to Congress, and Congress supposedly makes the laws, right? I mean, Congress is responsible for all this, right? Well, according to this, there is nothing. How you want me to pay? How am I supposed to do it? Can I write you a promissory note? You going to authorize it? You going to go ahead and create those credits? Do your double bookkeeping entry and balance the ledger and give me the interest that results from it? I don't know. Questions for you guys. Food for thought. I can't change your belief it's the most powerful thing in the world. What I can do is cause you to ask questions. And if you ask questions and you start to research it for yourself, you will see things in a different light. I can assure you that.